good morning, everyone. And I first want to thank Luohan Academy to have me today and to be able to participate to such challenging exchanges. So, I've been asked to say a few words on the privacy protection in Europe. Let me press this. Okay, so yes, privacy protection in Europe. The first thing you have to have in mind is that we are operating under a new legal framework, that is the famous GDPR. And this GDPR was it is a change of culture, it is a change of measures. It's not the change of principles in Europe since the EU directive of 1995, but it is a big and tremendous change in Europe. It was also a fierce political battle. It was a battle within Europe, because you can imagine that put together 28 countries with different cultures, different economic interests along the same text was quite a tremendous effort. It was also a big battle towards the outside world, because through the GDPR, Europe wanted to assert a kind of digital sovereignty, and of course there were forces that were not very happy about that. But still, the GDPR was adopted in 2016, and the legislators gave us 2 years to get prepared, and so it was operational since May 2018. So now we have 1 year of application of the GDPR. I just want to start by saying that it's important that we all realize that GDPR is on data protection, not only on privacy protection. And it's important to say this because sometimes I have reflections from people saying that privacy protection, this is a concept, a European concept. Maybe we're not so much interested by that. Privacy protection is related to human rights, which is very fine. But data protection is more related to the general sustainability of the digital ecosystem. So it's wider than privacy protection, and we have 2 separate articles in the European Charters of Fundamental Rights and also in the GDPR that shows that the 2 objectives are together in the GDPR. So, what is the GDPR? GDPR is not, it's not a dream. It is not a theoretical approach to data protection. GDPR is a practical answer to questions that most of our countries are facing. And I listed 3 of them, but probably there are others. But I think these 3 ones are probably common in between us. The first one is related to data governance. Until now, data protection was an issue in the legal departments, but mostly not of the operational departments of the corporations, and most often not a strategic part of the reflection of these corporations. The idea of the GDPR is to set really a real data governance in relation with the new role of data in economic model, in artificial intelligence, in public policies. The second issue of GDPR is to answer to the security issues. We are, yesterday it was said, more and more interconnected. And of course, if we are interconnected, it means data is flowing from one to the other, and data leaks could be very bad for the robustness of all the data sets. So, patching and answering to the major data leaks that we had in most of our countries in the recent years is also a very key an important objective of the GDPR. The third objective, it is a more complex one, but I guess that you also have been facing this kind of uncomfort from the general public. What is this uncomfort? And Ariane Moll will in a minute develop most largely the point. The uncomfort, it is to say that in the recent years, the general public, of course, is using all the digital services, but at the same time, they feel a kind of ill at ease towards these services because they feel that their data are used without them knowing exactly what kind of use, what kind of exploitation is made out of their data. This feeling has developed in the recent years, in particular through the Snowden revelation, 2013, and very recently with the Cambridge Analytica problem. Cambridge Analytica, you remember the big leak and the big 87 millions of data, 87 million people used probably to manipulate an election. So suddenly people realized that this digital ecosystem was functioning in a way they didn't know, that was totally not clear for them. And with the Data Privacy Commissioner, we had a big conference in Brussels last year in October 2018, and Tim Cook, the CEO of Apple, said, yes, there is a problem. The crisis is real. So it means this uncomfort of the end users reveal a kind of confidence crisis towards the digital society. And if there is confidence crisis towards the digital society and towards the digital economy, there won't be any growth of it. So having identified these three main issues, and probably others, of course, what are the objectives of the GDPR? First objective, it is to create a market, data market. Before the GDPR, this data market was fragmented into 28 national markets. Now, with one law common for 400 consumers in Europe, we have one European data market. Second objective, security, I said. Put the security as a top priority. Yesterday, we had a very interesting presentation about the digital ecosystem, saying that there were many actors in this digital ecosystem interacting each with each other. The idea of the GDPR is to put this digital ecosystem into the digital liability. If they are exchanging data, they should be, each of them, liable if anything happens and occurs with the data. Before GDPR, that was not the case, because before GDPR, the only possible person that could be liable was the data controller. Now with the GDPR, this is all the chain with subcontractors, processors that could be integrated in the liability process. So this is very important because the reality of the digital ecosystem enters into the legal framework. Data breach notification, this is a new obligation for data controllers. It means that if you have a data breach, you have to notify the data breach to the regulator and possibly to the end users. Of course, it is to raise awareness with the data controllers about the importance to patch the data breaches and to take measures, but it has also an objective of having more general knowledge about these data breaches in order to better understand and maybe to give better answers at each levels to these data breaches. And lastly, mandatory risk analysis. The idea is to integrate into the legal framework the idea that there is a risk, a possible privacy risk, and that it should be taken into account into the reflections. Third objective, of course, reinforcement of the rights of the individual. The idea of the GDPR is to rebalance the relationship between the professional actors, the business, and the end users. Again, to solve this kind of confidence crisis. So the idea is not to renounce to all the digital services, it is to give more power to the consumers or to the citizens to be able to be in control of the data. And so there are several provisions in the GDPR in order to strengthen the role of the individuals. And yesterday, again, some of you strengthened this idea that they wanted to have the human-centric. This is exactly the purpose of the GDPR, to put the human at the center of the regulation. By strengthening the consent, you know that the consent is one of the legal bases of the GDPR. The GDPR strengthens the possibility of consent to give new rights. Data portability is an interesting example, because data portability means you can be free from one social network, from one provider, and go to another one, even if you have developed a very long-term relationship with this provider and if they have been collecting a lot of data on you. Because with the data portability rights, you are able to recollect all the data you've provided to this provider and have it for you and possibly take it to another one. So it is, of course, I would say a sort of a social right, because you get what you have provided, but it is also a competitive right, because through that you can reactivate the competition around the data by bringing your data to other actors that will be able, maybe, to offer you new services. So this objective is really to have a stronger individual-facing data controllers and data processors. Another objective of the GDPR is to set up a real data governance. I said it was one of the key identified issues at the beginning. Really, the GDPR wants data protection to be operationalized, not a theoretical and legal requirement, but something that really is fueling the operational life of the corporations, public or private. And it is in line with the idea that all these actors using data, processing data, should be liable, should be more responsible for the use of their data. How can we build this data governance? Through what we call the accountability tools. The accountability tools means the tools in which a corporation will show that it is respecting the data protection. And the most important tool in my eyes, in my mind, it's the data protection officer. Data protection officer, this is an idea, this is a tool that is coming from the US, very much developed in the US, very less in Europe. The idea is that this guy, this woman, is really what we call the chef d'orchestre, the data governance officer inside of the corporation. He is in charge of making sure that data protection is present in all the department of the company. He should be close to the operational units, of course, to understand what it means to use the data in HR, in finance, in R&D, but it also should be close to the chairman, to the CEO. in order to be able to push decision. Another objective of the GDPR, of course, is to make sure that all of this is respected on the European territory by European actors, but also by international actors acting in Europe. And for that, we have several tools. The first tool, and it's not written here, is to high up the level of sanction. Why? Because if you high up the level of sanction, it means that you high up the cost of non-compliance. Second, it is to create an architecture of cooperation between the 28 regulators that is simplified and more efficient. This is this one-stop shop and the reinforced cooperation. Very simply, one-stop shop means that if you are acting in several European countries, you have only one regulator that is competent, the competent of the lead, the main establishment, the lead authority, what we call the lead authority. So an architecture of cooperation between the 28 regulators that is rather complex, but is aiming at being more efficient and simpler for the companies having to discuss with them. And third, an article that has been a lot commented, if not criticized. It is the famous Article 3 of the GDPR. And this Article 3 says, if you are operating in Europe, even if you're not established in Europe, but if you are targeting the European territory, then you have to respect European provisions. And this is a very important article because it ensures that the European law is respected on the European territory, even if you are not established in Europe, but if you are collecting data from European citizens. So this is a critical article for ensuring, I would say, the European sovereignty on its own soil. So I'll go quicker because I have the impression that time is running. What is the role of the regulators in front of this new GDPR? First, of course, to be sure that this GDPR is understood and known. So huge, tremendous educational effort that we made in the last year to make the GDPR known and understood. And as you see, on the citizens level, I mean, a real progress has been made. On the DPO, I was mentioning the DPO as a key tool inside of the organization. It is growing, so I think this educational effort has been quite effective. Second, and this is absolutely key, it is to help the cooperation in their compliance effort. Very often, regulators appear as being only police people. They're not only police people. In fact, the key role of the regulator is here, is to make sure that they help the compliance efforts of the organization. And I would say at the CNIL level, which is the CNIL, the French Data Protection Authority, this is a dimension that we have developed very much in the recent years by bringing new compliance tools to the industry. And we have developed, for instance, sectorial compliance pacts negotiated with the industry representatives in order for them to have their own operational objectives, but in the framework of the regulation. So I guess this dimension of the regulators is very important. And why is it important? It's important because we strongly believe that data protection is a competitive argument. And I'm sure that in the room there are companies that would agree with me. It is an element of concurrential differentiation between the companies. And the only role of the regulator is to find, through their advice, the right balance between innovation and, of course, protection through the regulation. Last but not least, the role of European regulation is, of course, sanction. Sanction, as I said, it is not the key objective of the GDPR, but it is a deterrence arm. If you don't have any sanction, probably you won't have any compliance. So sanction is important, but it's not the main objective of the regulators, but it is important because the GDPR has created a huge expectation from the general public through the complaints. You see the rise of complaints. So what is going to be important is if we will be able in 2019 to have credible and robust sanctions in Europe. I will be quicker because I'm running out of time. It is important because we will have question, I guess, around this question. And to conclude, what I want, my main message is to say that we strongly believe that data protection is the lever, the key lever for having a sustainable digital environment. GDPR is a huge attempt. It can be a reference, but it should not be copy-paste because there are many differences between our countries. And last subject I wanted to put on the table, it's the necessity of interoperability, because we see that there is a tendency to have a sort of fragmentation of regulatory regimes, and I guess fragmentation of regulatory regimes would be very damaging for digital economy. Thank you, and sorry to have been a bit long.